Most people think they understand what is happening to Donald Trump because they see the headlines every day. Court dates, appeals, delays, arguments between lawyers, poll numbers rising and falling. But almost all of that misses the real story. Because this is not about one trial. It is not even about multiple trials. And it is not really about Donald Trump alone. What is happening right now is something the United States has never gone through before. Not in its founding. Not during the Civil War. Not during Watergate. Not at any moment in modern history. For the first time, the American legal system is being forced to answer a question it has quietly avoided for more than 200 years. Does the law have the authority to put a former president on trial at all? Before a single jury is sworn in, before a witness takes the stand, before any verdict can be reached, that question must be answered first. And it is not being answered in New York or Florida or Washington, D.C. It is being answered inside the most powerful and least visible institution in the country, the United States Supreme Court. This is where everything truly begins. When most Americans hear Supreme Court, they think of landmark decisions, long opinions, and abstract constitutional debates. What they don't always see is how much power the court has, simply by choosing when to act and when to wait. When the Supreme Court agreed to hear Donald Trump's claim of presidential immunity, it did not rule in his favor. It did not clear him of any charges. It did not dismiss a single case. But with one quiet procedural move, it changed the entire legal landscape. Trial schedules stopped. Court calendars froze. Cases that were moving forward suddenly stood still. Not because the law had failed, but because the stakes had grown larger than any single prosecution. At the heart of Trump's defense is an argument unlike anything ever seriously tested before. His lawyers are not arguing evidence. They are not arguing facts. They are arguing power. They claim that a president must be protected from criminal prosecution for actions taken while in office, and that this protection does not disappear when the presidency ends. Under this theory, a former president can only be prosecuted if Congress first impeaches and convicts him. This is not a technical argument. It is a foundational one. If accepted, it would mean that criminal accountability for the highest office in the land depends not on law enforcement, not on courts, not on evidence, but on politics. On timing. On party loyalty. On whether Congress is willing and able to act while a president still holds power. For over 2 centuries, the United States never had to confront this directly. Presidents left office, norms held, power transferred peacefully. The idea that no one was above the law was assumed, not tested. But assumptions are not the same as rules. And Donald Trump has done something no president before him ever did. He did not step away from power under the shadow of potential prosecution. He challenged the system while seeking to return to power again. That single fact changes everything. The Constitution does not clearly answer whether a former president can be criminally prosecuted. It explains impeachment. It explains removal. But it is silent on what happens afterward. That silence remained harmless for generations, until now. And now, the Supreme Court must decide whether that silence protects power, or restrains it. What makes this moment especially dangerous is not just the legal uncertainty, it is the role of time. In an election year, time is not neutral. A trial delayed by months can become a trial never held at all. A verdict postponed can reshape an election without ever being rendered. And sometimes, the absence of a decision is more powerful than any ruling. This is why the Supreme Court's involvement matters so deeply. Because while the court deliberates, the rest of the system waits. And as it waits, the country moves closer to an election that may determine whether these cases ever reach their conclusion. This is not how the system was designed to work, but it is how it is being forced to work now. And this is only the beginning. Because while the highest court debates the limits of presidential power, a courtroom in Manhattan is already testing something just as profound. Not power, but accountability. And what happens there will force the country to confront something it has never seen before. A former president, sitting as a criminal defendant. While the Manhattan courtroom focuses on documents and accounting entries, a federal courtroom is preparing to confront something far more volatile. The aftermath of the 2020 election. This case is not about a single speech, a single phone call, or a single protest. It is about a sequence of actions that prosecutors say formed a coordinated effort to overturn a lawful election. At the center of the case is a simple but explosive claim that the transition of power in the United States was deliberately obstructed. According to prosecutors, the effort unfolded in layers. Public pressure on state officials, private lobbying behind closed doors, plans to assemble alternate slates of electors, legal strategies designed not to resolve disputes, but to delay certification long enough to change the outcome. Each step on its own might appear defensible: political advocacy, legal maneuvering, public protest. But taken together, prosecutors argue, they form a criminal conspiracy. The defense rejects this entirely. They argue that everything Trump did falls under political speech and official responsibility. That challenging election results, however aggressively, is part of the democratic process. That criminalizing post-election conduct risks turning political disagreement into prosecution. This is where the line becomes dangerously thin. In a democracy, political speech must be protected, even when it is uncomfortable, even when it is controversial. But democracies also depend on acceptance of lawful outcomes. The question the court must answer is where one ends and the other begins. Did the actions taken after the election remain within the realm of advocacy, or did they cross into deliberate interference with the constitutional process? Intent becomes everything. Prosecutors argue that intent can be inferred from coordination, from persistence after legal remedies failed, from pressure placed on officials who lacked authority to change outcomes. The defense argues that intent is irrelevant when actions are protected by presidential authority. And once again, everything circles back to immunity. If a president's official acts are protected absolutely, then this case may never reach trial. If they are not, then the courts must determine whether a sitting president can be criminally liable for actions taken while still in office. This is why the Supreme Court's ruling matters so profoundly. It is not just about Trump. It is about whether future presidents can test the limits of power without fear of legal consequence. If immunity is broad, the presidency becomes a legal shield. If it is narrow, the office becomes subject to criminal accountability for the first time. Either outcome reshapes the presidency. What makes this case especially dangerous for the system is that it sits directly at the intersection of law and democracy. A criminal verdict would not simply punish an individual. It would define what behavior is permissible for future presidents in moments of electoral defeat. A dismissal would not simply clear a defendant. It would establish that certain uses of power are beyond the reach of the law. And all of this unfolds while the defendant campaigns to return to office. That fact alone makes this moment unprecedented. Never before has a former president sought re-election while facing criminal charges tied to the peaceful transfer of power itself. The courts are not just adjudicating the past, they are shaping the future in real time. Public reaction has intensified the pressure. Supporters see the case as an attempt to criminalize politics. Critics see it as a necessary defense of democracy. Media outlets amplify every development. Polls fluctuate. Narratives harden. The legal system, designed to operate slowly and deliberately, is now forced to function inside a political hurricane. Judges must consider not only the law, but the legitimacy of the system itself. A ruling that appears too aggressive risks destabilization. A ruling that appears too lenient risks precedent. This is the trap the system now finds itself in. And as explosive as this case is, it is still not the most concrete. Because there is another case, less abstract, less philosophical, that introduces a different kind of risk. Not political power. National security. While the election case revolves around intent and interpretation, the classified documents case moves into far more tangible territory. This is not about speeches or political pressure. It is about physical evidence. Boxes of documents. Official markings. National security classifications. Subpoenas issued and allegedly ignored. Surveillance footage showing movement of materials. Unlike the other cases, the law here is not vague. Unauthorized retention of classified documents is illegal. Obstruction of efforts to retrieve them is illegal. These rules apply to everyone. Prosecutors argue that when Trump left office, his authority ended. Any classified material in his possession at that point belonged to the government. Repeated requests were made for their return. Subpoenas were issued, and according to the indictment, those subpoenas were not fully complied with. This is where the case becomes especially serious, because the allegation is not just possession, but deliberate obstruction. Prosecutors say efforts were made to conceal documents, move boxes, and mislead investigators. That intent, they argue, transforms the case from a paperwork dispute into a criminal matter. The defense responds with a familiar strategy. They argue that presidential authority over classification is broad and flexible, that intent matters more than markings, that a president can declassify materials at will, that confusion and miscommunication, not criminal intent, explain what happened. They also argue that enforcement has been selective, that others have mishandled classified materials without facing prosecution. But this case introduces something the others do not. Risk. National security is not theoretical. It is not symbolic. It is not subject to political interpretation. The government argues that classified materials exist to protect lives, intelligence sources, and military capabilities. Once those materials are removed from secure environments, the risk is real, regardless of who possesses them. This removes much of the political ambiguity. And yet, even here, presidential immunity is raised. The defense suggests that decisions about classification and retention fall within official authority, that a president's judgment cannot be criminalized after the fact. Prosecutors counter that authority does not survive the presidency. Once the office ends, so does the power. This creates a dangerous tension. If authority extends beyond office, then the presidency becomes a lifelong license. If it ends with the term, then the law applies equally to former presidents. Again, the Supreme Court's looming decision casts a shadow. If the court rules broadly on immunity, this case may collapse without ever reaching a jury. If it rules narrowly, the evidence may speak for itself. What makes this moment particularly destabilizing is the accumulation of pressure. Multiple cases. Multiple jurisdictions. Multiple theories of defense, all converging on one central question: where does presidential power end? The American legal system was never designed to process this kind of convergence. Criminal law assumes defendants who are not political movements. Courts assume rulings that do not shape elections. And yet, here we are. Each delay becomes strategic. Each appeal reshapes the calendar. Each procedural ruling alters the political landscape. This is not a failure of the system. It is a system encountering circumstances it was never built to face. And as the legal battles continue, history looms quietly in the background. Because this is not the first time a president faced potential criminal exposure. But it is the first time the country chose not to look away. And that choice may carry consequences far beyond any single verdict. To understand how dangerous this moment truly is, you have to look backward. Not to compare personalities, but to understand decisions. After Watergate, the United States faced a similar crossroads. Richard Nixon resigned under the threat of impeachment and criminal prosecution. The evidence was overwhelming. The country was exhausted, and then something unusual happened. Trust in institutions was fractured. Nixon was pardoned. Not because he was innocent. Not because the law lacked evidence. But because the country feared what would happen if it pushed further. The official explanation was healing, stability, moving forward. But the cost of that decision was silence. The question of whether a former president could be criminally prosecuted was never answered. It was buried under the logic of national unity. For decades, that silence worked. Presidents left office peacefully. Norms held. The assumption that no one was above the law survived without ever being tested. Donald Trump changed that. He did not step away quietly. He did not accept the margins of defeat. And he did not retreat from political power. Instead, he forced every unresolved question back into the open. By seeking re-election while under indictment, Trump created a collision the system was never designed to handle. Criminal accountability and electoral ambition now exist at the same time. This is why delay has become such a powerful weapon. Every postponed trial brings the election closer. Every appeal pushes resolution further into the future. Every unresolved case allows voters to interpret events through political loyalty rather than legal outcome. The system moves slowly by design. It values caution over speed. But caution becomes vulnerability when time itself reshapes consequences. This is not just strategy, it is structural. Courts cannot accelerate without risking legitimacy. They cannot slow down without affecting democracy. Either choice carries consequences. And the Supreme Court sits at the center of that dilemma. Its eventual ruling on immunity will not simply resolve Trump's cases. It will determine whether criminal law can coexist with presidential power. A broad ruling would send a clear signal. Official acts are untouchable. A president could test limits without fear of prosecution once out of office. A narrow ruling would reaffirm something older than the Constitution itself, that power is temporary and accountability endures. But even a narrow ruling carries risk. If future presidents fear prosecution, will they hesitate in moments of crisis? Will caution replace decisiveness? Will the presidency weaken under legal scrutiny? These are not abstract concerns. They are arguments being weighed seriously by the justices. And that is why this moment feels unstable. The legal system is being asked to protect democracy without politicizing justice, to enforce accountability without turning courts into battlegrounds, to preserve the presidency without placing it beyond the law. Public reaction only intensifies the strain. Every ruling is dissected instantly. Every delay is interpreted as motive. Trust fractures along partisan lines. Institutions that rely on public confidence are forced to operate under suspicion. And yet, the courts continue. Because there is no alternative. There is no roadmap for this moment, no historical script to follow, no precedent that fully applies. The system must invent its way forward using principles designed for calmer times. And that is why this period will not be remembered for a single verdict. It will be remembered for the attempt. The attempt to hold power accountable without breaking the structure that holds the country together. And as the legal process grinds forward, one final question remains unresolved. Not about Trump. Not about guilt or innocence. But about whether the system itself can endure the weight being placed upon it. As these cases move slowly through the courts, something else is happening at the same time. The country is watching itself. Every filing, every ruling, every delay is no longer just a legal event. It becomes a test of belief. Belief in courts, belief in elections, belief in the idea that rules still matter. For some Americans, these prosecutions confirm a long-held suspicion that institutions protect themselves first. For others, they represent a long overdue assertion that power has limits. Both reactions exist at once. And that is what makes this moment so fragile. The justice system depends not only on enforcement but on acceptance. Courts do not command armies, they rely on legitimacy, on the public's willingness to accept outcomes even when they disagree with them. That legitimacy is now under strain. Judges know this. That is why rulings are cautious, why language is measured, why timelines stretch. The system is trying not to fracture under the pressure of expectation, but caution has consequences. Each delay feeds suspicion. Each procedural pause becomes a political narrative. And the longer these cases remain unresolved, the more space there is for interpretation to replace evidence. This is not manipulation by a single actor. It is the natural result of a system moving deliberately in a moment that demands speed. Meanwhile, Trump continues to campaign. This fact alone reshapes everything. He is not a defendant waiting quietly for judgment. He is an active political force, framing the prosecutions as proof of persecution, turning legal process into rallying cry. That strategy does not require courtroom victories. It only requires time. Because in politics, unresolved questions are often more powerful than resolved ones. The courts cannot consider electoral consequences. They are not allowed to. But those consequences exist whether acknowledged or not. A verdict before the election carries one meaning. A verdict after carries another. No verdict at all carries its own weight. This is the paradox the system now faces. Act too fast, and risk appearing political. Move too slow and allow politics to fill the void. There is no neutral path. The Supreme Court's eventual ruling will clarify one question, but it will not restore simplicity. It will not return the country to a time when presidential power went unquestioned because it was rarely abused. That era is over. What replaces it depends on how this moment is resolved. If the presidency emerges insulated, future leaders will notice. If accountability is reaffirmed, future leaders will adapt. Either way, the boundaries of power will shift. And the shift will not be theoretical. It will shape decisions made in crises, in elections, in moments when restraint is most needed. This is why historians will study this period carefully. Not to judge personalities, but to understand systems under stress. Because what is happening now is not a breakdown. It is a reckoning. A confrontation between authority and accountability that was postponed for generations. And the outcome will determine whether the American experiment continues to rely on norms or whether it finally writes its limits into law. Only one part remains. The question that will outlast the cases, the elections, and the headlines. When this period is finally written about, it will not be reduced to court dates or verdicts. It will be remembered as a moment when the United States had to decide whether its principles were strong enough to confront its power. Because at its core, this was never just about Donald Trump. It was about whether the presidency is an office or a shield. For more than 2 centuries, Americans lived with an assumption rather than an answer. That no one was above the law. That the highest office in the land carried responsibility, not immunity. That assumption held because it was rarely challenged. Now it has been. The Supreme Court's ruling on presidential immunity will echo far beyond these cases. Long after the headlines fade, future presidents will study it carefully. Lawyers will cite it, advisors will plan around it, and the boundaries of power will be drawn accordingly. A broad ruling will tell future leaders that official authority protects them, even after they leave office. That some actions once taken from the Oval Office can never be judged in a courtroom. A narrow ruling will send a different message. That power is temporary. That office does not erase accountability. That the law outlives ambition. Neither path is without risk. One risks creating a presidency beyond reach. The other risks politicizing justice in ways the system must learn to manage. But avoiding the question is no longer possible. That opportunity passed the moment a former president sought to return to power under indictment. This moment has already changed the country. Trust in institutions has been tested. Norms have been exposed as fragile. Legal systems designed for ordinary defendants have been asked to confront extraordinary power. And yet the system continues. Courts deliberate, judges rule, procedures hold. Slowly, imperfectly, under enormous strain. That in itself is part of the story. Because democracy is not proven in moments of calm, it is proven in moments of pressure. Whether the system emerges stronger or weaker will depend not just on outcomes, but on whether Americans accept that accountability and power must coexist, even when it is uncomfortable. History will not remember this era simply for who won or lost. It will remember whether the law held, whether institutions bent or broke, and whether the idea that no one is above the law survived its hardest test. The answer to that question will define the presidency, the courts, and American democracy for generations to come.